if you die with debt, you really need to open a probate so that the creditors have, in Kentucky, they have 6 months to make a claim. So they have 6 months to say this person owed us this amount of money for this thing, and they have to be paid first. Now, there are exceptions for, the surviving spouse gets a little bit, but typically, the creditors will kind of have first access to everything. So in the case of a house, even if you left the house to someone, if it has a mortgage, if they can't pay off that mortgage, they would have to have it refinanced in their name or something like that. Or more typical, I would say, is the house is sold, the money's collected, and then split amongst the heirs or whoever was designated in the will to receive it.
Wow. So you made me think about regarding a spouse. If one spouse passes on, has debts, and the other spouse didn't sign for that debt, they have separate accounts. So would that spouse be probably responsible since they were married?
Typically not. But it kind of depends on, the contract that was underlying the debt. So some of them will say, your estate is going to be responsible for this debt. Your estate's always going to be responsible. Some of them will say, if your estate isn't enough to pay this, your surviving spouse, like if you're married, they will be expected to kind of carry this on. So it depends really on kind of how the debt was taken out. I've seen it go both ways, really just depending on the contract, that led to the debt in the first place.
I have one more question that I'm going to ask if they were interested, where you're located, how we can get in touch. Because I see now from this past death of that family member, it's like, even though I think I don't have anything, I guess when I come in, you'll ask me things that I might have something that I didn't know I had that, so anyway, but girl, I almost forgot. The other question I have, my circle, we're in the front of the line. That's what I call it. We're in the front of the line. So I have a close relative that has a paid off home. And so she's concerned, should I go on and sell it to my daughter now because I would want to leave it to her, but if somebody came after me, and so she's thoroughly confused. Or if she goes in a nursing home 5 years down the road, what's going to happen, or are you somebody that could help talk us through that kind of?
Sure. So that's it, it really kind of depends on what the goals are. Now, some people with a paid off home, they will go ahead and deed it to a child so that the child is the owner. And maybe they reserve a life estate, which just means they can live in the house for their lifetime, but the child is the owner of the house. But that's not right for everyone because, sometimes, we all want to think that we can fully trust our families. But sometimes, they make bad choices. And so, in an instance where you had kind of deeded a house to, let's say, your daughter, and then your daughter got into some financial trouble, that house is now an asset of hers that can be taken. So it can be a tricky situation, to kind of preemptively go ahead and give your house to someone, but it works for some people. Another consideration as far as a nursing home is if you're trying to qualify for Medicaid, you really can't own that house anymore. And so if you were to go ahead and give the house to a daughter and then you didn't need Medicaid for 5 years, that's not going to be considered an asset for you anymore. But that, you wouldn't be able to keep the life estate. So it really kind of depends on what your long-term goals are. If you think, some people are saying, I don't think I'll ever qualify for Medicaid because, the restrictions are, you can only have about $2,000 of assets, which is a lot of people just aren't comfortable only having $2,000 in assets. So if that's a goal, you have to, proactively plan for that. But if not, there are options because she could always just leave the house to her daughter when she passes away, or she could go ahead and, if she fully trusts her daughter, go ahead and give the house to her now. There are a few different ways to handle that, really depending on kind of what your long-term goal is.
Right. Okay. Then she said, but I've got another question. She said, Charlie, that's what she calls me, Charlie, ask her, because what I understand, once I meet her and talk to her, I'll get to come home with a blue folder. Are all your folders blue?
I actually I put mine in a binder. I put them in a black binder Yes. So
Okay, that was so
they are
funny.
printed on fancy paper though. So
Okay, because I was like, really? She said, yeah, you need to make sure you come home with a blue folder. And I thought, oh, I'm so glad I'm getting ready to talk to this attorney. But anyway, and then another question you mentioned about how, death can come and you're not expecting it. So with young people, do they need a will to leave their minors to somebody, or do you even have that say so? Especially if you're a single parent, can you will your kids to people?
you can name a guardian in your
Oh, Gordy.
will for your
Okay.
children. And I do think that's very important. Now, if you're a single parent and the other parent is in the picture, you can't typically say, that you want this person to step in your place. Generally, the children will just go to the other parent, and then, you might have grandparents visitation rights or something like that. So if it's a single parent and the parents aren't together, but the other parent is still in the picture, you have a little less flexibility. But yes, the benefit of naming a guardian in your will is you get to choose ahead of time. And so that makes the transition for the child just easier. They don't have multiple relatives fighting over who's going to get custody of them, because, they've already been through enough trauma that they don't then need a long drawn out court case saying who is going to be their guardian. And so I think it's really important to name that ahead of time. First of all, because you get to choose and you're the parent. And so, you can make the best choice for your children. You don't necessarily want to put that in the power of the court, to say who they think the best guardian would be.
That's good stuff. Then I got one more question, because I want to ask you about your school too. So maybe two more. You said you're a solo. What does that mean? You're a solo. You have your own office.
Yes, I have my own office. It's just me. We've got a receptionist, but I'm the only attorney. And it's, I started that right out of law school, actually, because I just wanted to be available for my kids. And, attorneys sort of have a bad reputation for working 80 hours a week and things like that. And that's just not the life I wanted. So I was like, I'm just going to go out and blaze my own trail. And,
that's probably why a lot of attorneys I've met seem so, they're not necessarily very oozy goozy with hi, how are you? It's like, and it's like, bless their hearts, they gotta miss out on life.
Yeah, but we have a bad reputation for being very unhappy as a profession, which is sad to me, because that's not how I wanted to live my life.
You and Robin are two of the most sincere, happy, nice people that but anyway, girl.
Well, thank you. Just to be grouped in with Robin in anything is an honor.
My God. And anyway, so then my last question before I hear about your business, because I saw you're helping moms, and I'm like, do you have to be a young mom? Can you be a grandmom or any T in front of it? But my next question before that question is, do you need will checkups? You know how you go to the doctor once a year or every 5 years, or is it just when you feel you need to revisit?
Usually I tell people if they've had any sort of big life event. So, when you retire, that's a good time, because a lot of times when people retire, their children aren't minors anymore. If you'd kind of set it up to where, your kids were going to be younger than 18, you might want to go ahead and revisit that, because now you can see they're adults. You can kind of see where everybody's life is leading them. So you might want to change that. If you move states, if you come into additional assets, that's a good time to revisit it. If your financial situation changed for whatever reason, that's a good time. But in general, a well-written will can take you through a lot of changes just as it is, because we sort of plan for contingencies. So if this person has passed away, then I want this to happen. If, this executor is not living any longer, then I want this to happen. If my children are minors, then I want this. If they're not minors, then I want this. So you don't have to, it's definitely not something you necessarily need to do every year. I would say look at it every 5 years, but really consider updating it once, something big has happened that you need to sort of look at.
Okay, well, I promise I'm not going to.
No, take your time.
When we do the will, do we need to tell people that they're in it or out? Or can they just be surprised?
They can